Okay, I'm Eric Schnapper. Yes, yes. So you can ask me about my more memorable moments in the court. Not necessarily, not necessarily related to arguments themselves. Well, the most unusual experience I have had, one which I am confident no one else has had and hope no one else will have yet again, occurred many years ago when I moved the admission in person of a young lawyer from the office I was then working. And I got up and recited in the words that one uses that I was moving his admission. I was confident that he possessed the necessary qualifications. And Chief Justice Berger said, "Thank you, Mr. Schnapper, your motion will be granted." All this seems quite innocuous until you know what follows. That night, when they were cleaning the hall outside the courtroom, they found in the potted palm, just in front of the metal detector, a handgun. Handgun that was registered in the name of the lawyer whose admission I had just moved and for whose qualification I had just vouched. This was, the court, needless to say, and properly took that very badly. The next time I came to court, about a month later, I was standing in the Great Hall chatting with my father. A gentleman came up, flashed a badge, said he was with the FBI and wanted to speak with me. We went over, I think we had a cup of coffee or lunch at Union Station, and he proceeded to ask questions related to this. The government wanted to prosecute him for something, and they then had to figure out what to prosecute him for. Possessing a gun on the grounds of the Capitol is a very serious crime, but he wasn't on the grounds of the Capitol as far as anybody knew. No, it was his gun, but no one had seen him with it. And so it occurred to the Justice Department, and I think this is a perfectly reasonable decision, that they would prosecute him for possession of a concealed weapon. Since presumably he possessed it, since he was there, it was found in the potted palm, it was his gun, had his fingerprints on it, but no one had seen it. So he was charged with that, and I was called as a witness, and I was called to testify as to only one thing, which is, had I seen the gun? To which my answer was no. That was presumably intended to establish that it was concealed. So I was in the witness room with the clerk and the marshal and all these other folks. And at the first trial, he was tried once and he got a hung jury. He then fired his lawyer. I would have given his lawyer a bonus, but he fired his lawyer. He was tried again, defended himself, and was acquitted. And I had to go back and testify again. And many years later, I was in the court and down on the ground floor, and they had changed some things around. I actually had to ask them which stairs I was now to use, and someone was walking me along, and I asked him what he did. He said, oh, he was the assistant marshal, and I'd given him my name, and I said, do you know the story? And he stopped me right there, and he said, we all know the story. So that was my most unusual experience. My favorite experience was last November moving my son's admission, something I've been looking forward to since the day I heard he was interested in going to law school. That, needless to say, is not related to the first story. No weapons of any kind were found anywhere in the Great Hall afterwards. Stressful. Well, I'm sure it was terrible. My first argument was a truth in lending case, which I argued in the fall of 1973. I think it was a Thursday, because at that particular time of the year, I was actually, 72, excuse me, I was running the McGovern for President campaign in Prince George's County. And so on election day, when everybody else went out to get the vote out, not much of a vote came out, unfortunately, if you remember how that campaign went. I was preparing for the oral argument in headquarters. I had no idea what I was doing. It was the second case I'd ever argued. I came in with a written out argument, which I probably more or less read. But there were two really memorable moments. My mother and father were there, and at one point, during the oral argument, my mother turned to my father and said, apparently fairly loudly, of the Chief Justice, that man is interrupting my son. And the marshal came over and explained to her that she was not to make audible comments of any kind. There was also a moment that didn't go well for me, but I survived it. I had noticed, listening to some earlier arguments, that Justice White and Justice Stewart, apparently for fun, had this thing they would do, where one of them, I think Justice White, would ask a lawyer a softball question, offer them an argument that seemed to be a good argument for them, and if you then said, yes, Justice White, that's our argument, then Justice Stewart would attack you for it, ask you aggressive questions about it. So I noticed that, and even though I was petrified and had no idea what I was doing, it had caught my attention. So in the middle of my argument, Justice White offered me up one of these arguments, and I knew it didn't really hold water. So I said, no, that was not an argument we were relying on. I'm sure I said it far less articulately than that. And Justice White said it again in a beguiling way. He said, surely, counsel, you could argue whatever. And so, against my better judgment, but after all, it was Justice White, and I'd only argued one other case anywhere, I said yes. And then Justice Stewart said, well, he thought I was right the first time. And I responded, so do I, but I didn't want to argue with Justice White. And I was young, and they let me get away with that. I think that when you do this repeatedly, you get a sense of the kind of arguments that work. You get a sense of the way to say things. You have enough experience with this that you're comfortable standing around. You have to be willing to tell members of the court things they don't want to hear and give them answers that they don't want. But also to make arguments in a measured way that the court will find credible. To some degree, the court does rely on the judgment of the lawyers before it. It needs to understand the context, the legal context of a question, and it needs to understand the practical consequences of the questions it's being asked. I think what any lawyer brings to it who's done this repeatedly, if they've done it the right way, is a degree of that kind of credibility. I think the Solicitor General's office has it institutionally. Individually, it just takes time. And so I think one of the things that shapes the argument of a lawyer who's been there before and expects to be back is an awareness of the need to husband your credibility with the court, to not make an argument that really doesn't hold water, even though it might sound good for your client and might even be helpful, but in the long term, the court was going to realize it didn't really hold water. And so I think anyone who's done this a lot, if they're learning what they should learn, is also sensitive to that. But I would certainly categorize myself as the least skilled of the people that have done this repeatedly. Well, I think people who've done this before have a sense of the kinds of arguments the court wants to hear, the kind of information the court wants about the state of the law, about a record. I can certainly remember seeing arguments where you could almost see members of the court throwing up their hands. They used to turn their chairs towards one another, start passing notes, and because of the layout of the courtroom, you could almost not see them behind the chairs. They would just find the argument not helpful. And I think that's a disservice to the court. Now, there certainly are circumstances where someone who's never argued a case before can do it effectively. But I don't think, I don't think anyone who's familiar with the court, if they had to have someone else argue a case in which they were the client, would dream of having someone who hadn't done it before. It's just gives you such an advantage. I think they should come from anywhere. I mean, I don't think the court ought to be trying to set rules for that sort of thing. I think it's, that there's a dynamic that emerges when the court takes the case, and lawyers who have argued before volunteer their help, and sometimes people take it and sometimes they don't. And and those conversations are complicated. But I think that's about how the system ought to work. And sometimes it works to the court's advantage, sometimes not as much as you'd hope. But I don't think I think it would be a very bad idea to try to regulate that. A certain amount of common sense works pretty well most of the time. I don't think there's any one thing. I find when I get in a situation where, I mean, my attitude towards oral arguments is that I won't fight over them. You know, I'll get in a case, I'll write the best brief I can. If I get asked to do the oral argument, fine. If not, I just move on. I've done the best I can. I just, as a matter of just professionalism, I will not put up a fuss about that sort of thing. But I have to say, to the extent I've had conversations about it, it is very difficult to convey to a lawyer who's been in court his or her entire life that they wouldn't be just fine at this. It's very hard. Some people have an instinct that there's something else going on here and they shouldn't try to do it. But some people don't, and I find it almost impossible to explain it to them. It's hard to explain how different it is from what other things you do as a lawyer. And people who understand that taking a deposition isn't like writing a brief don't instinctively understand that a Supreme Court brief is different than a lower court brief, or the Supreme Court argument is different. And yet, I'm sure that if you asked anyone on the court, they would tell you it matters enormously. And it's certainly my view.